All of us counsel were parties. We are counsel in that matter. But this is what court said at 141. On whether returning officer actually is gross to his powers to proceed to tally before receiving all the envelopes. The Supreme Court had to say this. I'll read this, but I would get the relevant. Furthermore, the petitioner did not adduce evidence to show that the declaration results forms were not filled in by the presiding officer after the closing of the polls and counting of the polls. Neither did he adduce any evidence so that when the returning officer opened the results envelopes before they received all the envelopes from their respective district, there was no police officer at the rank of the inspector police, and above all the candidates or their agents, bearing in mind the constitutional obligation imposed on the community to declare results within 48 hours. Now, this is what captured the same scenario, that you must go and prove to this honorable court that if you have a legal grievance under this section, prove two things. You do not have agents in the tally center. That is number one. Number two, that there was no police officer under that rank. Man, you cannot tally for life. There are time limits within which you have to declare a winning candidate. So a petition is not at liberty even to abscond or to make his agents abscond from there. If one is missing, at least have a police officer. My lord, we are faced with the question then which other law did the second response not comply with for you to sustain such a grievance? Then it brings me to a second bit of the complaint. That actually you're waiting for results. What happens? That there are no results. The procedure in the tally system is like this. And this is the sand. That polling takes place. It closes. The presiding officer fills the DRA forms, and the transmission process proceeds as such. Now, at that point at the tally center, the returning officer is receiving results. Now, this is what the law commands the returning officer to do. One, if you have an envelope and it does not have results, that is section 72.3. And I'm going to invite you to look at it. And this is the scenario that really happened. You are returning officer, you are waiting for results. The envelopes are coming. If you go to the envelope and you can't find results, it directs you to go to the report book. The law commands the returning officer, look at the presiding officer's report book. My lord, if you can't find it in the report book, the law commands you to go to the ballot box itself. My lord, there's a presumption that actually in those two, you'll find the results. The second thing the law recommended you to do is to reseal. The only requirement you need is again to have the other police officer at that rank. This is the scenario. Now, at that point, if you can't find those as a returning officer, right from section 72, is that the only option left to you as a returning officer is to declare. My road, the road does not tell the returning officer to run away. And this takes you to what the Petitioners Council was proposing, that actually what you are declaring are provisional results. No. These are not provisional results. I'm yet to be convinced by the petitioner in the principle set in Madrama's case, Webe's case, and Jim was, that the returning officer never complied with this section. The only option left is to declare as a returning officer. And those exceptions, my road, is what you noted yesterday in the case of Bet Mzanda. Those exceptions. And I invite you to rely on his case. Those exceptions that they gave to if results can't be found, 3 if they are missing. And by the way, this section does not even impose a duty on the returning officer to inquire. No. It only commands him that now that you have suspected that you have all this, there are possible ways of where you can find the results. Report book, the ballot box. After that, proceed to declare. And if you do that, you have not, that is not non-compliance. And my road, we have been guided by the Supreme Court on such a command of the registration in City and Asebaro. My lord, this is the election petition appeal number 6 of 2009. It is not up to the suitors, the petitioners, to propose a sanction within the law or to amend it within the law. My lord, while the Supreme Court was dealing with Section 50 of the Parliamentary Elections Act, then it was on the other forms. My lord, in that case, is that some results were declared on the woman, the dear forms of a woman, district woman member of Parliament. And the argument was that this was not a prescribed form. And what has this to say? That we observe the second phase of the Parliamentary Act, which prescribes the procedure in regard to declaration of various forms, does not prescribe what would be the effect or consequence of its non-compliance. It appears to me, and that is quote, that the section is directed in the sense that it directs how election results and paperwork connected here which should be done. Mere non-compliance with the stage in the procedure will not affect the results. And the appeal was dismissed. And in my road, when you retire to write a judgment, you retire a look and brace yourself to that decision. When you read section 72, it gives you the procedure. Like I've elaborated here, it gives the procedure. That even if we are to agree with them, that actually it was not compliant with that procedure, so long as the intention of the returning officer or an administrative body like Electoral Commission is achieved, it is not for the petitioner to say that has affected the results. And this is Supreme Court, my lord. And it's our submission that, my lord, that in a given scenario, the petitioner cannot purport to say that EC did not comply with the provisions of tariff and declaration. And actually, and indeed that was not provision results. And the question would be, then what would be the final results? And where do you read the provisional results? My lord, the results of an election is to be in the return form under section 77 of the Parliamentary Elections Act. My lord, that return form was properly filled. It is annexed to the petitioner's petition. So the process was complete. The tally sheet and the DR forms of 183 polling stations, which translated to 92.7% of the registered voters of Kawempe. That result represents 92.7% of total registered voters of Kawempe. Interruption. He coached, the petitioner coached her complaint on section 76. Interruption, postponement, and counting tallying process. My lord, you're faced with a very peculiar situation. What this section presupposes is that actually when the violence erupts, you are given time to prepare and safeguard electoral materials. That's what it presupposes. That you hear noise, people are carrying stones, the mob is being organized, then the electoral body very fast secures the electoral materials for you to be able to postpone the counting. And my lord, this is what comes out in the other evidence, supporting evidence. What is not in contention is that the polling process was peaceful in the 14 polling stations. That measures had been taken by a second respondent to put all electoral materials in the press. Voters stand up in huge numbers to cast their vote. Polling closed at 4, with no major incident reported by the petitioner. Only other person in the electoral process. But from the evidence of the supervised or designated officers is that at the point of sorting, all those who have participated in the process, is that this process of sorting, Nambi Farida, it is here. Nalukoola, it is here. Nsereko, it is there. After that process of sorting, there is a heap here, there is a heap here. Now, the winner will be, is suspected. The loser is suspected. And I don't want to be misquoted for people saying that maybe this could have been attributed to any of the parties. That is when the mob came in and smashed, destroyed the key electoral materials. And these are the key electoral materials, my lord. And that will take him back to section 72, because you cannot evaluate section 76 in this total disregard of section 72. What were the key electoral materials? One, the report book. Where the returning officer is directed under 72. Two, the ballot box. Three, the DRA forms. My lord, that is the process that the 14 police that was interfered with.
All those materials were destroyed.
Destroyed. It's an act of God, maybe. But that was an act of Satan, maybe, because God doesn't act that way.
None of the parties is responsible.
But none of parties is responsible for this. And none benefited. Might not be different if the winning candidate gained a fair advantage. And how do you tell that they would have gained a fair advantage? If at that point maybe the rest of other politics had been done, that may be number one. You'll say maybe this one gained because he was losing, they may organize. And the other, of course, suggestion is for the other parties, none gained. My lord, a person, a petitioner, cannot come to this court to take advantage of this act of Satan to take us back to the polls. I made this is where I want to plead that this court now he has been under Article Section 82, 5, rather 4, that places you a duty to inquire. What has intended the inquiry could be the evidence, and indeed it is in this evidence, that before you take your decision, make a thorough inquiry. That are you going to give us a decision or a precedent that politicians or supporters of politicians, my lord, or politicians, my lord, or supporters of politicians will always organize themselves in a mob to interfere with the process to access this court? Is this the precedent that we are going to look for? Moreover, in a situation where none of the parties benefited, my lord, we have got it from supporters that actually all politicians, be it winning, be it losing, are desperate to win. And that's why court, in one of the authorities, submitted it that even when you are evaluating their evidence, is that you have to give it a care, attention on that. But it calls for wisdom from the presiding judge. that he did not want to have a judgment that is going to set a precedent that supporters can interfere with the work of the electoral body to fail it to declare or to use it as a vehicle for a by-election. And why, my lord, I say it calls for wisdom. Much as I'm a lawyer, I've been forced, my lord, to get one of the interesting verses of the Bible in making a decision. That is 1 Kings chapter 3, verse 15. And my lord, this is about the story of King Solomon. We are all familiar about that story. When he was confronted with a child, and the child is Kawempe, and he said, now what do you want? The other person said, kill. I'm not meaning the petitioner, I don't want to be misquoted. The judge said, aha, no. My lord, you need that wisdom. Because this precedent only calls for wisdom. The petitioner also had strange proposals and invoked a non-applicable section. But if I take leave of that, my lord, then in the circumstance, what did the returning officer, after declaration, as responsible as administrator of elections, what did he do? My lord, when you read the affidavit of the returning officer, I think it's paragraph paragraph 11, that the following day, the returning officer reported to police. Under CRB 350 stroke 20, CRB 350, my lord, stroke 2025, and CRB 356 stroke 2025. Prudently, that's what an administrator or a returning officer will do for them to investigate. The report was about the violence that was reported to him on the 14 polling stations. And I'll take you there, my lord, to evaluate. Because like I earlier submitted, the electoral process is a progressive nature. You're already there. The law does not say go down. You're in the transmission process. You must first complete the tallying process. One would presuppose, maybe like the petitioner wanted, that please hold on to the envelopes you have, rush to police, investigate. No. The flowing river principle applies. Finish the process, have the winner declared, then report the relevant authorities. And this is what the returning officer did. My lord, that fact by the petitioner has not been responded to in the rejoinder, has not been denied, simply to be put. And as we speak, maybe the investigation is still ongoing. And that's what we can do as an electoral body, that we give the relevant authorities to investigate. That for you to suppose that you stay the returning process, you wait for the envelopes under section 72, my lord, that is not tenable. and that is not a command of section 72 on the tiring process. My Lord, we'll take it to a fourth complaint of the petitioner, that at cross-examination of the petitioner, she says, I couldn't get 100 in the 14 polling stations. Yes, I could win in some, but I could not get 100. And that's why I was, then what? You don't want to be declared? You don't want anybody else to be declared? Where is our child? So, under the inquiry, my road, that is an area that will invoke the first king, Solomon, for your decision. Then, my Lord, after taking all those alleged non-compliances, and having convinced you that actually none of the provision was not complied with, and indeed, there's no section of the law that has been pointed, there's no evidence to that effect, then where there's non-compliance? Missing you, that was no non-compliance. I would squarely have stopped at this. But if you're inclined, my Lord, to find any law notes, the framers of the law never anticipated that you are going to have an excellent election. And that's why they said they framed it to be free and fair. Not excellent and exceptional. No, these are gradings. That is number one. Number two, that actually it is not enough to annul. It is not enough to annul. That non-compliance must be substantial. So you have a huge burden as a petitioner. That will test my road. And it appears to me the petition is only on the numbers, on the data test, on the quantitative. And this is where our point of departure is. I really associate myself with the principles of the law, in as far those authorities were supplied to my Lord. But onward depart. Where my Lord, and I must applaud Mr. Karure, that when he gave some judgment, he picked those that favored him.
Portions of the judgment.
The portions of the judgment. My Lord, you need to. I refer to one of the judgments, my Lord, Acheng Saropendi. It's a court of appeal. It was supplied by him. And my Lord, I'll refer you to page 21. I'll give you my copy as well. What do we consider? My Lord, counsel for the petitioner omitted the good way he is to bring this fact or principle of the law to you. This is the authority that I'm trial judge have compared the aggregate number of registered voters from the 17 polling stations of 8,144 together with the winning majority of the first appearance, and then conclude by washing away the first appearance winning majority.
That's what the petitioner wants God to do.
Now this is what he wants you to do. This approach overlooks the fact that each candidate at this election suffered equally from the decision of the Electoral Commission to exclude the votes from the 17 polling stations from the final tally of the results. My lord, there's one angle. In fact, here, the Electoral Commission had omitted. Here we didn't even omit, that there was none to omit. And this brings me to all the decisions that were supplied by counsel for the petition. And the only distinguishing factor, my lord, is that in all those decisions, there were results. And maybe at this point I should distinguish them. There are results. That's number one. Number two, in that in all those decisions, my lord, the results had been tampered with in terms of altering them, in terms of returning officers deliberately, not including them in the tally to favor the other candidate. But more interesting is that in those, the margin was very slim. I invite your lordship to look at them as well and be able to deduce the fact that indeed they are not applicable. My lord, the court, after faulting the trial judge, they went on to say, the respondent therefore had to decide the burden that she should have got the majority of votes if the votes from the 15 polling stations are taken into account. She had the requisite evidence to prove or disapprove this. She did not adduce it, and thus she failed to discharge this burden. So, my lord, all along, what counsel for the petitioner was to invite you to consider the 16,640 registered voters vis-a-vis the difference, which is 8,000 plus. My lord, this judgment, which supplied by himself, says no. That is not a formula. That you cannot give here and wash away. Because you owe the petitioner, the respondent, you suffered equally. My lord, this is the submission of court.
There is a copy.
Chi amatendera chi akakiiko k'ebyokulonda kirina okugobera bwebanga kali mu tallying process, kubanga bo bagamba nti twayangwa okulangirira nga tusose kwetegereza kiki ekyabeera mu 14 polling stations. Naye teeka libadde ng'anyonyera kooti likirambika bulungi bw'oba nga tolina address ng'oli mu tallying process ky'olina okukola. Kikugamba olina okusooka kugenda mu report book. Bw'ogenda mu report book naye oba olina okubeera ng'olina ba agency bo oba ng'olina omusulukale w'eddaala ranka bagitaddeko mu mateeka. Bw'osanga mu report book nga tiri mu results, ogenda mu ballot box. Bw'osanga ng'ebyo byonna tolina, option gy'oba olina oba olina okulangirira ani yawangudde okusinziira ku envelope z'olina. Ky'abantu balina okutegeera nti ebyo banga bitibiriiwo, tolina okubeera kulangirira. Naye n'ekirala kirina okukakasa eggwanga nti etteeka erigamba nti olina okwongerayo okubala kiba kisinziira ku stage kye y'oliko. Wabeerawo assumption nti ebintu by'olina okugenderako bye already safeguarded. Kambayo ekyokulabirako nti by'obadde ng'ogenda nga ballot papers kyali safe, kyali secured. Voters registers kyali secured. Ballot boxes zali secured. Naye kusinziira ebyaliwo ng'ebyo byonna baabimenya n'obwopostponinga kiba nga kikyolina kirina okukola. Naye n'ekirala kirina okutegeeza nti kimbadde nga mbulira omulamuzi okugamba nti olina okulonda mu bitundu ebyo 14 nakyo kisoboka kubanga at that point of when you're sorting polling stations endala ziba zamaze okutegeera ani yawangudde naye abantu abangi abamu bwe bamanya nti oli batuwangudde eri era noboozamu okulonda wano oli abadde yawangudde eri bamuwa just kubanga tebagala kusosietinga noli eyaki bawangudde so nekyo nakyo kisoboka nebyo ebyo byeteeka lyerigamba naye kugamba nti twagoberera ebyokulonda amateeka g'okulonda ekyo kya bulimba ekyo tikiriyo ngerinda ze kooti n'omusalamu ya kooti yebadde nga weeri n'ekirala kimulina okutegeera nti twalina abalonzi emitwalo kumpi 2 bali mu police station 196 twalanga ebyava mu kulonda mu bitundu mu polling stations 180 plus kati bwogenda mu percentage ebeera percentage ya 92%. Kati ka percent yakabulako kalinga almost 7%. Naye abantu 7% balina okusalirako abantu ba 92%. Kati tosobola kwemulugunya mbyokulonda bitabeerawo mu mutwalo gumu n'ekakaaga noleka ebyabeerawo mu mutwalo 18. Okiraba? Kati n'ekirala kimba n'engamba bwe twamukanyuka ebibuuzo wali ntumugamba wali osobola nti osobola okufuna obululu 10 buli wamu wabona kufuna yagamba nedda wali osobola okuwangula yagamba nedda nange binsobedde awo n'engamba waayi
kanso bagamba batataganya abantu abali batwala ebyokulonda kyogeddeko mu kooti kibuulireko the interrupted the officers and the process.
Olaba bintu bya kooti si bya just kwogera kyolaba mbale nga siba wa interview wano mwogera ebirala omusango wali ebirala mu kooti ojja n'obujulizi kubanga obujulizi obutulina buli omu neya petitioner bonna bagamba nti okulonda kwali kwa mirembe kuva ku makya mpaka sawa 10 nibagala obulungi nibabala akavyo kaja wano nga basootinga kati wekoye point is a point of no return kubanga kyebane bagamba nti processes zaffe zi progressive in nature tosobola kuddayo gwe watandikidde obanga ogenda nga kumaliriza kati eri returning officer bwatandika kufuna envelope ye alina okutandika processes ze okiraba mpaka olina okumaliriza kubanga at the end of the day abantu abalonze balina okufuna ni yawanguda oba ni bawanguda ani tosobola kuholitinga process mpaka di kubanga tosobola kukola process endlessly kyolaba bateekako nti olina okulanga ebyava mu kulonda ndakiika musaawa 48 were ekyo kyobuuziza mbadde wano ebbanga nakakwera emisango mingi okuva 2006 waliwo trend z'obuildinga mu kooti kooti bw'osalawo n'okuleetinga president ab'ebifuzi bagikozesa kati buli omu abanga bakozesa ekintu kipya naye wano kooti bw'osatifyinga nti basupporters b'abantu abamu bwe batuuka bali kusootinga ne bakikikisa nti balemye nakujjako polling station za 2 oba 17 n'agamba nti akuleetinze another window ogenda kwemulugunya wano mu kooti n'okasazamu bangi bajja kubikozesa kubanga ffe tulina okukivumira ekyo condemn tulina okukondemminga eyo process nekisobola kugiikiriza nti ebe one of the presidents nga akakiiko ebyokulonda bategeka akaloola kalina okubeera ak'obwenkanya nti supporters b'abantu oba hooligans ababeereeyo oba yana abalonze bonna basobola okujja ne bateekako eno mbeera.
Mukubira twagala okwebaza lawyer wa Hajati Nambi kubanga bambi yakoze obuvunaanyizibwa bwe era obujulizi yawadde bulungi nnyo ekyennaku nti mu kusala emisango tetukozesa bujulizi bw'abalooya tukozesa bujulizi bw'abo abajja mu kooti ng'abajulizi ba witnesses n'oyo abawaabye omusango nga mwenna mwena mbadde mugoberera omusango guno ekirungi nti gubadde public. Mukyala Nambi n'abajulizi be balemererwa okukola obwo obuvunaanyizibwa obw'omuwaabi obuteekeddwa mu mateeka ga Uganda naddala ku nsonga z'ebyokulonda ku issue esookera ddala eya compliance oba waaliwo okugoberera amateeka g'ebyokulonda era nga n'ogenda mu maaso okulangirira nga tetufunye results za polling stations 14 oba ku affecting ebyokulonda ne kutuusa n'okusazaamu ebivudde mu kalulu bawaddeyo obujulizi bwe bawaddeyo naye nga emulabye olwaleero electoral commission ng'esooka naffe ne tutandika nti kooti ensukkulumu mu Uganda Supreme Court yasalawo eggoye ku ki ekirina okukolebwa mu mbeera ng'eno mu Kizza Besigye ne Museveni 2011 kooti ensukkulumu yasalawo negamba nti okujjako nga gwe oluzinze osooka olaze nti bakuwangula n'obululu butono nnyo then obwo obululu obutaabalibwa bwe obutaayongerwako bulina okuba nga bugenda kyusa Victoria yo yawangudde. Hajjat Nambi ne baloya be kye batakoze mu musango guno kutuleetera bameka abalonda ate nga tukiraze kooti ensukkulumu mu Besigye ne Mwamama Mbabazi 2016 egamba leeta obululu bw'ogamba bwe wandifunye. Okulonda kuli ku numbers, tekuli ku conjecture, tekuli kuteebereza, tekuli ku kyewandiyagadde nga gwe agize mu kuwaaba, tukozesa bwino na numbers. So Hajjat Nambi ne baloya be kye baagala kooti ekole bakwate abalonzi abali mu polling stations 14 omutwalo ogumu akakaaga 16,640 babamuwe babwongere ku bululu bwe. Kooti enkulu ensukkulumu mu misango gyonna gya Mama Mbabazi ne Kizza Besigye ate ne kooti ejulirwamu mu musango gwa Sarah Opendia Cheng omubaka w'abakyalo ow'Etororo ate nga kirungi ne Mwami Kalulero ya Nambi yaguleese. Kooti egamba kiba kikyamu okukwata namba y'abalonzi n'ogigatta bugasi ku bululu bw'oli awanguddwa kubanga tekisoboka mu bulamu bwonna nti abantu 100 ku 100 abalonzi ku polling station bayinza okuvaayo ne balonda ku lunaku lw'okulonda ate ne balonda omuntu omu. So ensonga gye tuliko era nga baloya we tukiraze mu kooti singa Hajjat Nambi ne baloya be batutte obudde ne basoba omusango gwa Kizza Besigye ne Museveni singa petition eno bagijjayo nkya n'olwaleero olweggulo kikyasoboka ne tuteesa ku ngasi because tulaba nti balina gye bagenda byakuwaddawaddako bwaziwazi. Issue za bribery ze baleese nazo tezirina simba era tulaze kooti atugenda giragana akawunge n'olweggulo lwaleero mu kuwoza kwaffe nti ne Nambi bye yaleeta bya wolokoso ayina ebintu bingi byawaayiriza ba agents be ate nga ba agents be tebabyogera era kooti tugenda giraga ekyo kyennyini. Aba agent bonna babuziwa ebibuuzo nga bazze wano ng'abajulizi era ba agent omubuuza walabako Nalukoola ng'awa omuntu sente agamba saamulabako yakwata bando nnene zaali sente mmeka sizimanyi yazimuweera wa simanyi era mbadde mukiraba nti twabadde tubatuumye amannya gaabwe abasinga atwongeddeko erinnya lyokusatu simanyi I don't know nayo yafuuse erinnya ttongole eri abajulizi abasinga abazze mu kuwa obujulizi. So tetulaba nti mu mateeka gagamba nti oba ogenda sazaamu wiru y'abantu olina okufuna ensonga ey'essimba a very strong reason. So kati 92% ey'abalonzi balonda ne kye baagala bakibuulira eggwanga mu Kawempe North. Kati ogenda kozesa 7% ey'abantu b'otamanyi gwe walina ba agent ku polling station balina okuwandiika abantu bameka abalonze buli polling station tebakikola. Kati gwe nojja ng'oyagala kooti okukolera ogwo omulimu etegeera abalonda etegeera abandikulonze etegeera abandironze Nalukoola mu mateeka obwo buvunaanyizibwa tebukyuka tebudda yamuwawaabirwa. Eggulo yabadde agamba nedda beegaana bwegaanyi naye tebaalaga ngeri ki gye beegaanamu. Mu mateeka omuvunaanyizibwa wange egamba nti nedda wemba mu lusoga bbe nkoba bbe then the responsibility of proving yiyo gwawaabye. So tulaba nti Honorable Nambi ne baloya be tebakoze buvunaanyizibwa obwo era tusuubira nti kooti ejja kuba guided. N'ekisemba era kye tusabye kooti nti wabaddewo lack of consistency. Kirungi nnyo gwe nga client oba ojja mu office yange nga lawyer n'ombulira ebizibu bye byavudde mu kulonda nina okunyonyola nti bambi nga mu ndaba yange olina omusango oba tolina ki tolina musango. Obuzibu bwe tubadde nabwo nti kooti z'ebyokulonda naddala kooti ejulirwamu egenze yeekubira oludda petitioner oba parent waba pate eno nemuwa judgment ya mufavoringa naye ate ng'ekyusizza amateeka oba tegoberedde kooti ensukulu mu Supreme Court kyeyagamba. Era kyetusabye kooti olwaleero nti n'emisango gyonna Nambi ne balabe gye baleese givoola era gikontana ensala ya kooti ensukulumu. Ate nga Commonwealth country tufugibwa president ebyaliwo bakikola batya bakama abo. Kooti eno gye tulimu kooti nto Supreme Court era tugisuubira okuba nti egenda kugoberera Supreme Court kyeyasalawo ku nsonga zonna era singa ekigoberera tetulowooza nti Honorable Nambi asukkawo wano. Waliwo affidavit addala ya Nabakoza Rita kansala yajja nawe obujulizi gundi yabubuuza lawyer wa Nambi oba yali agenze mu maaso ga lawyer akola oath gwe bayita commissioner era mu kuddamu kwe n'agamba nti yagendayo. Ebirala bye yamubuuza oba yalabako ekitabo mu mateeka oba ogenda kulayira bakukkiriza okukozesa Bayibuli, Qur'ani oba obutakozesa kintu kyonna mu buwangwa bwo oba nga tokkirizibwa bikozesa ebyo. Kati bino ebibuuzo byonna mwami Kalulete yabibuuza Nabakoza oba wa buwangwa ki oba yakkiririza mu Bayibuli oba takkiririza mu kikyakozesa okulayira. So kiba kyabuusa okuba nti kati saawa eno osaba kooti nti ejjemu obujulizi bwe kubanga teyalayira kubanga ye mu bujulizi bwe bwonna yagamba nalayira. Ate ekyokubiri nawe yajja mu kooti yakwata Bayibuli n'addamu n'akola ki n'alayira era n'addamu byonna ebiri mu affidavit ye. Mu misango egisaliddwawo kooti ensukulumu nga mugwamu Gema Peter ne Mudyobole kooti egamba oli ne waaba yalina affidavit evidence n'ajja mu kooti n'awa obujulizi byonna byayogedde mu kooti ng'awa obujulizi biba bituufu era kooti erina obigoberera. So kooti terina basis yonna kweyinza kusustaining'ira objection ya Hajjat Nambi ne baloya be okuggyako obujulizi bwa Nabakoza. Naye era kitegerekeka kubanga Nabakoza obujulizi bwe buba bukuba ebituli mu Nabukenya. Kubanga Nabukenya yagamba yakuba ebifaananyi twamutuma essimu n'abulirayo we yakomawo nga wayiseewo ssaawa 4 n'agamba bbaawe ate yatutte essimu. So n'omujulizi yalina okuggyako Nabukenya eyali agamba nti yaprintinga ebifaananyi tusuubira yafuna ekidumusi n'abula era teyajja. So obujulizi bwonna bwe baalina ku nsonga eyo ne bugwa. Kyobalaba nti kati bagezaako okulwana okulaba nti Nabakoza eyakuba ebifaananyi eyajja n'essimu ye ya Samsung Ultra S23 baagala buveeko kubanga bubanyigiriza. Naye tetulina buzibu bwonna kubanga obuvunaanyizibwa bw'okupuruvinga busigala bwa Hajjat Nambi tebukyuka kudda waffe.
Ensonga y'abajulizi okuliwisi nga bagamba mbuno bakuba ebirayiro nga nannyini musango tannabakuteekamu nenkwewozaako tukinyonyeko mu Uganda engeri gy'omuzigambe.
Ekyo tukimaze kubanga obuzibu bwabwe bwa kusoma teeka kifuula nnenga upside down and that's what they did kubanga rule 8:1 ey'amateeka g'ebyokulonda egamba nti ojja teekayo obujulizi bwo mu nnaku 10 ekitegeeza nti olina okunoonya obujulizi bwo bwonna mu nnaku 10. So tekitegeeza nti bonna abajulizi bwo olina bakuŋŋaanya mu lunaku lumu bakole obujulizi mu lunaku lumu. Mu election pension gwe Silivia oba ogenda kumpa obujulizi bwe nkufuna olwokubiri mpa obubwo ogende okola emirimu gye emirala. Ekikulu kiri nti byonna nina biteekayo lunaku lumu era ne musango guno bwe kyakolewo obujulizi bwakuŋŋaanyizibwa mu nnaku nga 7 ne buteebwa mu kooti nga 24 ogwokuna. So tewaliwo obuzibu bwonna bwali mu kuba nga deeti za njawulo bwe bakuŋŋaanyiza obujulizi.